Coming to the topic today, we are all a little baffled by the sudden announcement of the draft by the central government on the 6th of January 2025, giving out two things. One is the UGC draft regulations, the other one is the UGC guidelines for faculty. Now, the time given for us to raise objection is up to 5th of February 2025. But to say something about this notifications and public announcements and asking for objections, these are all what we experience over the years as great strategies which are more political and less academic, I would say. Because at the time when the union government wanted to introduce the new education policy, they tried to justify that we all published the entire thing throughout the country and conducted several deliberations, invited objections, and later on we are slowly implementing. But what happened to those objections? Nobody knows. All objections are received. We all promptly sent objections, but none of the objections were ever considered. And what was the final outcome? Normally, when a draft is published, it is obviously tentative in nature. It is a provisional, temporary. It is subject to the finalization after the receipt of your objections and other things. And India, with a population of such 1,140 crore people, with thousands and thousands of institutions, the notification says that exactly 30 days time for the entire nation to respond. Obviously, it is an empty ritual, but still, we have to go on record raising our objections. For today's discussion, I don't wish to enter into the domain of these academics or the educationists' jobs, namely how far these regulations or these guidelines would have an impact on generally on higher education in the country. But that's a larger subject. I think that is not, this is not the appropriate forum to discuss all those things. Now we are convened, assembled here as minority educational institutions. Now the question that is looming large is how far these regulations would have an adverse impact over the long cherished constitutional and fundamental right that has been guaranteed to the minorities over the years. Now the draft regulation says that the government is planning to revise the earlier regulation in operation, that is the 2018 regulation. And the amendments, what they're trying to introduce, the composition of the selection committee, the nature of advertisements that ought to be made while selecting the faculty, the principals, and the vice chancellors. You might have read in newspapers over the past 3 or 4 weeks, huge that objections that have been raised by states that are not ruled by the BJP government, or mainly pertaining to the appointment of vice chancellors, because vice chancellors are the academic head of universities, and we are in a university system. Therefore, the fear that is expressed by the states over the past few weeks, or about the fear that emanated in the minds of the states, suppose these regulations are implemented, they are scared that the federal structure of this country, insofar as education is concerned, would certainly get destroyed. We must always look this text rather contextually. What we are experiencing over the past decade is in almost every non-BJP run states, we have governors who are functioning more as obstructionists rather than promoters of federalism. That is the main fear that is expressed by the states insofar as the vice chancellor's appointments are concerned. But I don't find any of the state governments raising their voice in respect of any other aspect, namely the criteria of selection, the system of selection, and the qualifications that are prescribed, the methodology that is prescribed for assessment of qualifications, so on and so forth. All their political agitations or insofar as the Vice Chancellor's appointments are concerned. But here now we are not much concerned about the Vice Chancellors, but anyhow, we will have a brief discussion on that a little later. To start with, the notification is made on the 6th of January 2025, asking us to share your valuable feedback on the draft regulations on or before 5th February 2025. There are 3 paragraphs in this notification dated 6th January 2025. The first paragraph talks about the proposed regulations, that is what we call in short form as UGC regulations of 2025, and the guidelines on cadre ratio, period of probation, confirmation, leave, so on and so forth, the service conditions of the faculty and the staff. Second paragraph also mentions about these 2 regulations and guidelines. But what they are asking for as objections or your feedback is only with reference to the regulations and not with reference to the guidelines. That is what the last paragraph asks us to do. And coming to the regulations, we must consider how far this proposed regulation is running contrary to the earlier regulations that are in operation, namely 2018. If you turn, I hope that all of you might have that draft regulations in your hands. If you turn to page number 4, that is paragraph number 3, general conditions, recruitment and promotion. This is the what they talk about the faculty recruitment as well as promotion in colleges. 3 things they emphasize. The first is merit. The second is advertisement. Third is the selection committee. Merit, we are not going to agitate because we are all setting as role models for maintenance of good merit and standards. In fact, all the governmental institutions must learn from minority institutions insofar as merit and the qualifications and high standards of education are concerned. Therefore, merit is not the problematic area. But the second one is advertisement. What they say is that advertisement shall be on all India basis. So when you propose to appoint even at the lowest cadre of assistant professor, or you want to directly recruit an associate professor or principal, or might be by way of career advancement, an associate professor or professor, every time you will have to make the advertisement all India. And this all India advertisement is not without any basis because there will be a flood of applications from all over the country. And you will have to wade through the thousands and thousands of applications that may reach your doors. This actually was challenged earlier when the earlier regulations contemplated or rather prescribed these kinds of all India advertisement as a requirement. Third one is the selection committee. What they say is merit shall be the rule, invitation should be all India base, and selection should be by way of a selection committee. The composition of the selection committee is also described in the regulation, the later part. So far as the assistant professors posts are concerned, the selection committee will be composed of 6 people. And in fact, a majority of them are from outside, not from the inside institution. First, let me tell you something about this first requirement of advertisement. Earlier, the 2000 as well as 2010 regulations, as well as 2018 regulation also prescribed this all India advertisement a little more elaborately, saying that it shall be by way of official website, all India newspapers, this and that, at radio, television, so on and so forth. Those regulations were put to challenge before the Madras High Court. The argument was when Constitution confers the right of appointment of staff as an essential facet of the larger right of administration, which is a fundamental right, whether the state or the center or the University Grants Commission or any other body for that matter have the power to even prescribe or regulate our absolute right of selection of staff. The High Court said that the mode is up to them. They may advertise, they may not advertise. The one and the only thing you can look at is, namely, by the university while granting qualification approval, or by the state when they are extending the fund by way of a grant in aid towards the salary. All that you will have to look at would be only the qualification. Qualification, obviously, you know that mainly composed of two factors. One is the academic qualification. The other is the experience qualification for the particular positions. Except these two, no authority, either the union government or the state government or the universities or any other bodies like the University Grants Commission or the All India Technical Commission or Bar Council of India or Medical Council, no authority will have the power to poke their nose into the inside administration of a minority college as to how they are inviting the candidates. They may invite or may not invite. The person in charge of the administration may even choose to just peep outside the window and call somebody and appoint him as the faculty. All that he needs to satisfy is the qualification. Therefore, there are mainly three components in these regulations. The first one is invitation of candidates. Second is the selection of candidates. Third one is the qualification of candidates. The High Court has held repeatedly, so far the Madras High Court is concerned, that the first two components are in violation of the rights of the minorities. Therefore, they are declared as unconstitutional and hence void. They can't be applied against minority educational institutions. Why? Because those two have a direct adverse impact on this absolute right of choice of staff and the methodology of their own selection. The one and the only thing that is to be followed by the minority institutions, and which in fact we ourselves invited, was the qualification part, namely the third part. Now coming to advertisement is whether good or bad, that is not the criterion. It is not for us to analyze whether this all India advertisement or regional advertisement or local advertisement or statewide advertisement, which one is good, is not the criterion. The criterion is who are you to prescribe? It shall be our right to prescribe. When the state does not have the power to poke its nose in the power of administration, the choice of candidates is an integral part of the right of administration. Thereby, the state's power to interfere is completely negated to that extent. Therefore, I'm not talking about whether it would be better for you to go for advertisement at the national level or state level. I'm not on that. I am exclusively on the legality of it. The power to prescribe is absolutely absent, be it the center of the state or the University Grants Commission. You may advertise or you may not advertise, or you may be content with the notice board advertisement in your own college. The only thing is that when you choose a person, that person must have that academic and experience qualification. That is all. Now, the thing is that when merit is put in the forefront as the criterion for selection, the question arises of who is to assess the merit. The UGC proposed regulation says that it shall be assessed by not the college or the minority management, but by a committee that is prescribed under these regulations for direct recruitment as well as for career advancement. That is dealt with at paragraph number 4.2. It says that the entire selection shall be by way of a selection committee as per the provisions made under these regulations. If you look at the composition of the selection committee, for each cadre, namely assistant professor one committee, associate professor one committees, professors one committee, and the principal another committee. The composition is for assistant professors, the committee will be composed of not less than 6 people, 3 from the college and 3 from outside. And if a person happens to be, namely, suppose thousands of candidates apply, one of them happen to be a scheduled caste or scheduled tribe or other backward classes, or happen to be a woman, then, or a person with a disability, then the 7th person will come into that composition, and that 7th person will be the nominee of the vice chancellor. Thereby, the committee, when it considers any candidate, and I don't think that you would have any kind of selection without at least one SC or ST or OBC or minority or women candidate or person with a disability. Certainly, among the numerous candidates, one will certainly belong to these. Interestingly, these items are scheduled caste, scheduled tribe, other backward classes, women, persons with the disabilities. Another thing is a minority. We are all minority colleges. Obviously, the candidates will be in majority from the minority community. But even if one candidate happens to be that minority community, then the number of the selection committee will stand increased by one more, that is 7. And the 7th person will be nominated not by the college or by the educational agency, but by the vice chancellor of the university. Therefore, you can't have any committee, if you have a committee, without the majority being from outside. As I said, the composition generally is 6, 3 from the inside the college, 3 from outside the college. The 3 from inside the college are the chairperson of the governing body. Number 2, the principal of the college. 3rd is the head of the department. Suppose physics is going to be the department to which we are making appointment, then the head of the department will be from physics. 3 external experts selected by the chairperson of the college governing body or equivalent statutory body from a panel of 5 names approved by the relevant statutory bodies of the affiliating university and recommended by the vice chancellor. Therefore, first 3, namely from inside, and again may not necessarily be minorities, because you may have a principal who is a non-minority. You may have a head of the department who may be a non-minority, and the chairperson alone will be the minority. Suppose you are making appointments to the Department of Physics, and incidentally, the physics department has a head who is not a minority. You can't avoid him. You will have to necessarily have him. Therefore, it is the position or the designation that matters, the principal and the head of the department. Even assuming for our benefit that all the 3 are minorities, namely the chairperson, the principal, and the head of the department happen to be minorities, well. But the other 3, no doubt you can choose 3 from a panel of 5 people. Those 5 people are not enlisted or empaneled by you, but those 5 people are empaneled by the university statutory body, maybe the syndicate or the administrative committee or the convener committee, whatever name they call by. The university prepares the panel of 5 people and recommended by the vice chancellor. So the preparation of the panel is by the statutory body of the university and recommended by the vice chancellor. The vice chancellor can say, don't prepare 5, you can prepare 50. I will select 5 and recommend only 5. And you know the system of appointment of vice chancellors in this country now. Invariably, in every case, it is common knowledge that every post of vice chancellor carries a price tag or some kind of political affiliations or ideological confinements. These are the kinds of vice chancellors we have now. In this situation, contextually looking at this requirement of 3 external people, subject experts, what they call, they are absolutely outsiders. Maybe the dominant control in the nomination of those 3 would be in the hands of the vice chancellor. Assuming the 3 insiders are minorities, obviously there is no guarantee that the outsiders are going to be from minority community. It will be the chancellor's or the vice chancellor's choice only. So the balance is made 3 plus 3. And certainly every selection process would definitely contain a woman candidate or a scheduled caste or a scheduled tribe or other backward or minority or a disabled person with a disability. The moment one of those applicants happens to belong to any one of these categories, then the Vice Chancellor will have again the right to nominate another person from his hands. Thereby, the strength becomes, the selection committee's composition becomes 7. And the insiders are pushed to a minority, 3. Outsiders are 4. The regulation says decisions are to be taken by majority. Obviously, the 4 will take the decision. The 3 insiders who are from the minority community or minority institution will have to simply sit as mute spectators, watching what is happening around. You can't make appointments other than the recommendation from that committee. This is absolutely disastrous. They are completely depriving the minority institutions of their choice. And outsiders come inside the institution. Probably there might be chances where candidates, namely your own faculty members, would be practically selected at the chambers of the vice chancellors, and their names would be carried by these 4 people from the chancellor's chambers, vice chancellor's chambers to the college campus. And they would invite you to sit along with them and say that we are 4, we have the majority, and we have this candidate chosen. You can't escape from that. So also for every other category of positions, namely associate professor, and principal. So for the principal's posts are concerned, paragraph 7.0 deal with that. There again, the selection committee is almost of the same nature. And here again, for a principal, even though you have umpteen number of people who are eligible inside your own campus, you can't do that unless you have an all India advertisement. It very clearly says, paragraph 7.3, the selection procedure and selection committee. The selection of the principal shall be through an all India newspaper advertisement and by a duly constituted selection committee as per the provisions of these regulations. The selection committee for the post of principal shall have the following composition: chairperson of the governing body, 1 member of the governing body or equivalent statutory body of the college, then 3 external experts nominated by the vice chancellor of the affiliating university out of the panel of names approved by the relevant statutory bodies of the universities. Here, the composition becomes 1 plus 1 plus 3, namely 5. And out of the 5, 3 are from the table of the vice chancellor. And time and again, the courts have been holding that the posts of principals are very, very significant. Not only they are the academic heads, but the Supreme Court very picturesquely describes the position of the principal as he is the cog on which the wheel of administration revolves. And the most significant position because he is the academic guide, the academic controller, and participating in all kinds of bodies, statutory bodies. And he is the person who will have the academic correspondence with all affiliating and recognizing bodies. And it is, in fact, he is the center of administration. Therefore, the Supreme Court has been telling the governments and the universities or the other bodies shall have no right at all in interfering with the nomination or the selection or the advertisement, nothing of that sort except the qualification. But this is completely ignored while this regulation has been framed under paragraph 7.0. And 7.3 talks about this selection committee composition, what I read to you now. Then again, a new system is introduced insofar as the principals are concerned, namely, a principal cannot be appointed for periods beyond 10 years. And that again shall be by 2 terms, each one for a period of 5 years. Paragraph 7.2 talk about this tenure. A principal shall be appointed for a period of 5 years with the eligibility for appointment for 1 more term, following the procedure prescribed for selection of principal. However, he or she can serve as a principal for only 2 terms in the same college. After completing his or her terms as principal, the incumbent shall rejoin the parent organization with the designation of professor or in the professor grade, provided he or she fulfills the eligibility criteria for professor. Therefore, each term of 5 years, the principal has to undergo a selection process. Suppose you appoint a principal and who does the job extremely well and completes the term of 5 years very successfully. For the 6th year, the same selection committee will walk into your campus from the university to see and assess again the principal who has got accomplishments in your own institution. Only when the committee gives the seal of approval, that gentleman can continue for another term as a principal. This is something very devastating, because a person who has been doing a wonderful job is asked to stand before the committee again to establish that he is meritorious still and he has got the credentials. And another thing is that why this term of 5 years, I don't understand. And it has a supplementary prescription saying that after completion of his term, he will have to go back and sit as a professor or the professor grade. And nowadays, the vice chancellors are doing this rather shamelessly. They sit in the university as vice chancellors. After the term, they go back to the department and sit as professor or associate professors. And they do it maybe for reasons best known to them. But imagine a situation where normally when we appoint senior most people as principals, and after their great accomplishment over the years, for 10 years namely, they will again go back to the department and sit as ordinary professors or in any position which is of professor grade. There is neither any logic, nor any rhyme, or nor any reason over this prescription. Let us see what was the position earlier. The position earlier was, now we are actually confronted with series of regulations starting from UGC regulation 2000. Then 10 years later, 2010. Then again 8 years later, 2018. Now the proposed 2025. If you look at the original 2000 regulation, it prescribed the selection committee, the advertisement, and this qualification. But prescribing this advertisement, the High Court declared that it is void, unconstitutional. The selection committee also was declared as unconstitutional. Qualification was upheld. Actually, minority institutions even in Tamil Nadu did not choose to challenge these regulations immediately after their proclamation. They took several years, maybe sometime 7 or 8 years, to challenge that because of the pain they underwent, namely hundreds and hundreds of faculty members and numerous college principals' appointments remained unapproved by the universities because of the fact that those appointments had been made not through the selection committees. Even principals also were languishing without approval. As a consequence thereof, no salaries for the teachers and the principals for several years, maybe 5 or 6 years, which eventually forced the colleges to come to the court and agitate. The cases were taken up sometime in December 2010, challenging the 2000 regulations. Arguments happened almost 10 years after the regulations came into force, not because of the court's delay, but because of our delay in coming to the court. In the course of the argument in 2010, we advanced the argument saying that this kind of a prescription of advertisement and selection committees are absolutely rotten. It's in the teeth of the constitutional protection. Sensing the pulse of the court, because the primary argument was that who are these outsiders who are to come inside and select our own principal and our own faculty members? That was the primary argument. Sensing the pulse of the court, the UGC rose up to the occasion and very hastily and suddenly issued the 2010 regulation. When the case was going on, arguments were going on the validity of the 10 years prior regulation of 2000. The new regulation 2010, what they placed before the court all of a sudden was a good attempt made by them to tell the court that the basic complaint of these minority institutions appear to be the introduction of the induction of outsiders into the college for the selection process. Therefore, what they suggested was they came out with the new 2010 regulation saying, so far as the nominees from the university side are concerned, we will make the nomination, namely the university, not by panels created or prepared by us, but let the panels come from the colleges. Let the college submit names of 20 people as experts and external experts, out of which we will choose 2 plus 2, 4. Therefore, 20 plus 20, the names will come from the college, and the vice chancellor will pick and choose 2 plus 2 from the 2020. Therefore, the fear that was expressed by the minority institutions that outsiders are possibly coming inside got allayed by the new regulations. That is how they placed before the court. But nevertheless, we still persisted in our argument. This is not the one and the only argument. The main constitutional argument is this kind of prescription itself, even prescribing to us that you may have your own people, that prescription part itself is violative of the freedom of choice of faculty members for our institutions. You can't be heard to say, we shall select the people in a particular method, we shall select people with a particular committee. All those things are beyond your power to suggest. We don't want to take your suggestions. Therefore, the question revolved around the power of the University Grants Commission to make such suggestions by way of regulations. The court ultimately held not only the 2000 regulation as unconstitutional, but even the 2010 regulations as unconstitutional. Please remember, there was no formal challenge to the 2010 regulation. Because it all happened in the course of the arguments, we did not actually file any cases separately challenging the 2010 regulations. Because the UGC placed before the court considered it, and without a formal case challenging that, the court still said, this is a 2010 regulation, be it good or bad, that's not our concern. Where lies your power to prescribe? And we don't find any power on the University Grants Commission to prescribe such things insofar as minority institutions are concerned. This is how the case got resolved, and I would remember that because I appeared in those matters. The city of Madras got 270 faculty appointments got approved and got their salaries. And out of the 8 minority colleges in the city of Chennai, 7 college principals who did not have approval and salary for several years got approval and salary because of that judgment. Everything went on well for another 8 years. Then comes to 2018 regulation, reiterating the same as in 2010. Namely, the composition will be 7, 3 will be from the college, the 4 will be from the university, but undoubtedly from a panel submitted by the college to the university. Thereby, you can avoid non-minorities coming into the college. That was not formally challenged by us. By applying the 2010 judgment, which had occasion to consider exactly identical provision that was available in 2010 regulation, the courts were taking the view the judgment stands, UGC regulations cannot dilute the judgments. Thereby, 2018 regulation was actually pushed to the back burner, and it was not implemented against minority institutions in the strict sense. Very interestingly, what we see today, after 7 years, 2025, the draft regulation doesn't talk about even the panel to be submitted by the colleges to the university for nomination. On the other hand, they go back to the 2000 regulation, where the entire nomination by the vice chancellor shall be from his own people, not from and out of the panel submitted by the college. Thereby, it is quite evident and explicit that our colleges' appointments of principals and faculties would be certainly by these kinds of committees, where the majority decisions will be taken by the majority, and the majority is always from outside, not from inside. If you have a policy that Reverend Sisters and Reverend Fathers will have to head the institution as the principals, that is no longer possible. because they may not even choose a father or a sister, or not even a Christian. They can choose anybody. They can pin down on a person whom they select from the vice chancellor's chambers and bring to the college and do that. Very interestingly, why this 2025 regulation doesn't take into account the previous two regulations, 2018 and 2010, which at least suggested the panel system from the colleges. That is completely ignored, both for the case of principal as well as for the faculty. This is the present position. And as I said, this empty exercise of calling for objections is, I feel that they are only empty exercises. But still, we are duty bound to respond by telling out all these things to the government and the University Grants Commission, because now the minister has actually published this, right? The minister has published this. And they say that draft regulations and guidelines were launched by the Honorable Minister of Education, Dharmendra Pradhan Ji, on 6th January 2025. But this is done in the University Grants Commission letterhead. University Grants Commission is supposed to be an absolutely autonomous academic body, which is supposed to function independently on academic affairs. Why this regulation is not published by the University Grants Commission is not known to us. And these objections, they say, share your valuable feedback on or before 5th of February 2025, to whom is not addressed, but an email address is given as draft regulations, UGC government in. I say that legally looking at the matter, the University Grants Commission came to be constituted, all of you know, sometime in 1956 by virtue of the parliamentary law, the University Grants Commission Act 1956. Section 26 empowers the University Grants Commission to lay down principles, policies, and guidelines for maintenance of academic standard all over the country. Only by virtue of that power under Section 26, all these regulations are being proclaimed. Government has a power under Section 20 of the same Act that will be to just to regulate the commissions. Suppose the commission takes a policy decision, a regulation which actually adverse to any policy, which will be affecting in the larger interest, the nation or its external relations with other countries or something like that. Then in those situations, the union government has got the power to say something against the University Grants Commission. But very surprisingly, even before the University Grants Commission takes into account all these things, the minister comes in. It is he who takes over the whole job. It is he who actually publishes it on the 6th of January 2025. Therefore, now it is quite obvious that both the University Grants Commission as well as the political government have already gone through the matter, or maybe even jointly produced this matter, and just asking for your feedbacks, which according to them is very valuable. But anyhow, how far they are going to be valuable, I do not know. Anyhow, let us make our give feedback. And all these things we have to raise certainly as affecting the rights of the minorities. One very important thing that I fail to understand is when especially the previous regulations, though they were declared as not applicable to minorities, still at least they had some kind of consideration for minority institutions. But here, in this regulation, proposed regulation, there is absolutely nothing which is said about minority institutions. Absolutely nothing. We can say that something can be improved, but this is not an improvement, but this is again a debilitation of the rights of the minorities. When earlier things at least protected to a little extent, because I understood that except a few states, other states somewhat followed this 2010 and 2018 regulation. And at least they were happy that the vice chancellor's nominees actually came from our own panel. When this regulation comes, it is actually a retrograde. It is a destructive of even those small rights that were actually taken care of in the previous regulations. So this is the position now. And governmental interference in academic affairs has been something which is completely frowned upon by the courts and by all kinds of higher education commissions starting from 1948. All of you know. Even one of the statements I actually made some remarks about that, what was submitted by no less a person than Dr. Radhakrishnan as the chairperson of the Higher Education Commission, first commission that was set up by Jawaharlal Nehru in the year 1948. He said the foremost reform is to free higher education from the hands of the politicians. That is what he mooted. And today what we see is completely the other way around. Politicians proclaim even the proposed regulations, which all believe are supposed to be academic. And how far these politicians are having expertise in this matter, I do not know. But what we experienced over the years, maybe at least over the past 10 years, is all these kinds of things are proposed, published, invited, that objections or valuable feedbacks were invited, but we do not know what happened to all our feedbacks, either supportive or opposing. Nothing happened after this. And maybe we are running short of time, but this doesn't matter. 5th of February, they would have already made up their mind to publish it. And this empty exercise they want to finish within 30 days for these 140 crore people. Anyway, let us do that. So I hope that I have given some broad idea about the proposed regulations. And coming to the Vice Chancellors, just I would take another 2 minutes and explain to you. Paragraph 10 of the same regulation talks about the Vice Chancellors. And if you look at the Vice Chancellors' appointments are concerned, we have now two kinds of state universities. One is the central university category, the other is the state university. Central university is why we call this, because universities came to be established by or under the laws made by the parliament. Those are called as the central universities. Similarly, every state legislative assembly passes some law and thereby establish state universities. Now, what we see in this selection process of the vice chancellors, a search committee has been prescribed with the three people, and the three persons are a nominee of the visitor chancellor, and who shall be the chairperson of the search committee. Number two, a nominee of the chairman of the University Grants Commission. Then number three, a nominee of the apex body of the university, such as a syndicate, senate, executive council, or board of management, or so and so, so and so. Therefore, the search committee is composed of three people. Two are from the center, even for a state university. For example, we have a dozen universities in the state of Tamil Nadu, and all these vice chancellors of these state universities will be from any part of the country, carrying any ideology, with any kind of political affiliations. Because this search committee composed of three, one poor man will be from the university. And again, that when once that university is headed by a vice chancellor selected in this particular pattern, that state university is going to be under the control of that type of vice chancellor. And the whole lot of three people will be from that sort of people. So practically the state universities are going to be headed by vice chancellors selected not by the state, but by the center. Because the first person, namely the nominee of the chancellor, chancellors are invariably governors. Governors are themselves nominees of the center. So that nominee of the center will give another nomination. Number two is the nominee of the chairman of the UGC. You know that the UGC is the central body again under the control of the central government. Therefore, there will be a nominee from UGC. And the third is the state university's nominee. Maybe at present we have state universities under the control of vice chancellors appointed by the state. But once this regulation comes into operation, even that vice chancellors will be from outside if this is going to be the selection method. So naturally, all the three in the search committee would be from the center, and it would be grossly an encroachment into the basic federal structure of this country. That is about this. And now the term is again prescribed as 5 years or 7 years. And the age is prescribed as 70 years. And the consequence of violation of these regulations, there is a rider at the end saying that if you, as a higher educational institution or the universities, violate any of these parts of this regulation, then that will entail in penal consequences. Namely, they have cataloged debarred from participating in UGC schemes, debarred from offering degree programs, debarred from offering ODL and online mode programs, removed from the list of higher educational institutions maintained by the University Grants Commission, and the higher educational institution shall be subjected to one or more of the above actions. Further, UGC may take additional punitive actions as per the decision of the Commission on a case-to-case basis. Therefore, this is declared as not only a regulation, but a penal thing, which is mandatory, and the breach of that would entail in very severe and gross punishments. And your institution will be debarred from providing any courses which will end in the conferment of a degree. This is the status of the present proposed regulation. Apart from the state government's opposition in respect of vice chancellor's appointment, we as institutions are duty bound to raise our, or rather give our feedback, valuable feedback, raising all these concerns. That is what I would suggest.